Good afternoon, everyone, and welcome to the latest webinar from the section of Civil Rights and Social Justice. During the 2017-18 bar year, our goal is to rapidly respond to government action or other news that might impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from our subject matter experts. We encourage you to check the section website, www.americanbar.org/CRSJ, our Facebook page, and our Twitter handle for more news and information and replays of our great programming. If you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop and offer to our members and the general public. During today's program, we invite you as our attendees to ask questions of our panelists. In the right-hand control panel for this program, you'll see a questions drop-down box. And please ask your questions there, so we will be reviewing during the program to answer them during the final Q&A section. We also draw your attention to your handouts where you'll have access to a few articles on the subject. Today's program, entitled Facebook, Cambridge Analytica, and the Future of Consumer Privacy in America, is moderated by Alan Butler, who's the Senior Counsel at the Electronic Privacy Information Center and also the Chair of the section's Privacy and Information Protection Committee. Alan, take it away.
Great. Thanks, Paula. And thanks again to the section for hosting this. Welcome. Again, I'm the Chair of the Privacy and Information Protection Committee of the ABA section on civil rights and social justice. I'm also Senior Counsel, as Paula mentioned, at the Electronic Privacy Information Center, a nonprofit organization based here in Washington, D.C. that focuses public attention on emerging privacy and civil liberties issues. I'm going to quickly introduce the panelists and then give a bit of background on our topic today, which is Facebook, Cambridge Analytica, and the future of consumer privacy in America. I'll walk through the sort of who, what, when, and how of this issue, and then I will hand it off to my other panelists to discuss some of the implications, legal issues, and questions about what happens next. So quickly to go around, I'm joined by Amie Stepanovich. Amie is the U.S. Policy Manager of Access Now, and in that capacity works to ensure that laws and policies on surveillance and cybersecurity recognize and respect human rights. She also manages and develops Access's work on U.S. policy and leads global projects at the intersection of human rights and government surveillance. She was previously liaison to the ABA's Cybersecurity Working Group and one of my former colleagues here at EPIC. David Brody is an Associate Counsel and Fellow for Privacy and Technology at the Lawyers Committee for Civil Rights Under the Law. He focuses on issues related to technology and free speech, hate group activity, consumer privacy, government surveillance, and racial discrimination, and was also one of my former colleagues at EPIC. Jody Westby is the CEO of Global Cyber Risk LLC, a boutique firm that provides advisory, forensic, and technical services focused on privacy, security, cybercrime, and cyber risk management. She has more than 20 years of technical, legal, policy, and business experience, including specialized expertise in cross-border data flows, IT governance, and global business environments. So that's the panel, and without further ado, I'll step in here and talk about this issue. I imagine most of the attendees here are generally familiar, certainly with Facebook, which is a giant social network that most of us probably have some interactions with, maybe less familiar with Cambridge Analytica, but have probably heard over the past 2 months a lot about these two companies and what happened. Just to give a bit of background, Facebook, obviously, giant social media company with more than 2.2 billion monthly active users globally. Cambridge Analytica is an offshoot of a British political consulting firm with offices in the United Kingdom and the United States that previously offered data mining and analytics services for elections, including so-called psychographic profiling of potential voters. The firm was hired by Donald Trump's presidential campaign, as well as the Leave.eu campaign, Ted Cruz's presidential campaign, and many other campaigns dating back to 2014. The company declared bankruptcy on May 1st following these revelations and investigations into its improper access to Facebook data and other election activities. but they're currently, I believe, still being investigated in the UK as well as the US. Alexander Kogan is a research associate at Cambridge University in the Department of Psychology and founder of an analytics firm, but also worked with Cambridge Analytica in this case. And in particular, he created a personality quiz app on Facebook called This Is Your Digital Life in 2014. It was downloaded by approximately 270,000 users. They used, and by using the Facebook social graph feature, Kogan was able to scrape data of more than 50 million users, now an estimated up to 87 million users, and transfer that data to Cambridge Analytica via Strategic Communications Laboratories, its UK affiliate. So that's basically what happened. It was reported in several outlets on March 17th, 2018, although it had been, as many have noted, including Jody, reported before that, that Cambridge Analytica and its affiliate had improperly accessed and stored data on now an estimated 87 million users. That data was exfiltrated by Kogan through the quiz app and sent to Cambridge in what Facebook has now argued was a violation of their platform policies. Facebook says they first discovered the violation in 2015, removed the app, and demanded certifications from Kogan and all parties that they had destroyed the data, which they claim those parties gave. But I think the question more fundamentally is sort of how did this happen? Well, as I noted, the mechanism, the sort of specific data transfer mechanism here is pretty straightforward. Users that downloaded the app that Kogan had created were essentially paid small amounts of money to take personality quizzes, but unwittingly, by logging into the app, they were granting access to not only their own personal information, but the app was also accessing profile data that they could see on Facebook. So essentially, you have a user logging in, taking this personality quiz, which many people over the years have probably had experience doing on Facebook. But by doing so, at the time, they were giving that application access to everything that they could see on Facebook, which included profile information such as locations, interests, more granular details about newsfeed activity of photos of other users that are their friends or their connections that an app that didn't have those permissions would not be able to access. So Cambridge Analytica essentially paid Kogan as a cutout to obtain this Facebook data in order to build these profiles of voters that they could then sell to election campaigns. The New York Times and The Intercept reported that Kogan was able to collect enough profile data on at least 30 million users to match them with other records that would enable the firms to build these types of detailed psychographic personality profiles. There's a whole separate kind of literature and discussion right now going on about whether this type of psychographic profiling actually works, or whether what they're selling is essentially some form of electioneering snake oil. But regardless of whether it works or not, the data was collected by the app and essentially sold by Kogan to Cambridge Analytica. So I think the mechanism, as I said, is pretty simple at the time, and I think the bigger, more fundamental question is, how did we get here? I think it was a result of failures on kind of every level. I think there were regulatory failures here in the United States, possibly in the UK. I think there have been legislative failures that have sort of led to this point in the United States, certainly, but also failures of corporate accountability and more broadly, I think a failure to prioritize these types of data protection issues in the United States. Going back even further than the period in 2014 and 2015 when this app was first developed, I think it's important to understand a bit of the background and context related to Facebook. Facebook has repeatedly made material changes and alterations to their data collection practices without user consent. On numerous occasions, it's changed its settings to enable broader dissemination of user data without users' awareness, including access by third-party apps and platforms. As early as 2009, a coalition of consumer privacy organizations led by Epic filed a series of complaints with the Federal Trade Commission regarding these practices at Facebook. In particular, Epic flagged the improper disclosures on the news feed, changes to settings in the for the users where their private information became publicly available, and also very broad access by the platforms on the third-party platforms to user data. Basically exactly what Cambridge Analytica did, was flagged as all the way back in 2009. And there was a supplemental complaint in 2010, and in 2011, the FTC and Facebook announced a proposed settlement related to unfair and deceptive trade practice claims against the company. And it was an eight-count complaint. There's information available about that settlement in the handouts, but the highlights of it were claims against Facebook for deceptively changing its privacy settings to make previously private data public, deceptively giving access to third-party platforms beyond what was necessary for their functionality, also deceptive use of targeted advertising. And then as a result, Facebook agreed to get express consent from its users before making these types of changes, and to maintain a comprehensive privacy program, including with outside assessments or audits. Epic actually followed up after the settlement was proposed and suggested a number of ways that it should be bolstered, including making those audits actually public, and also limiting other types of invasive tracking like facial recognition, tracking of users across the web, and allowing users to actually access the data that Facebook has on them. Yet despite that initial action by the FTC, to bring Facebook under consent decree, that the agency hasn't taken follow-up action since that 2012 finalized consent order. And in particular, we haven't seen enforcement action related to continuing violations of the issues that were flagged in the original complaint. Facebook, in defense of itself in the Cambridge Analytica situation, says, well, after we found out about what Kogan had done, we turned off, or we reduced third-party app access on the platform, but that was in 2015. And this consent decree had already happened in 2011, 2012. Epic's complaint was filed in 2009. So why was that data available in 2014 to the app, to Cambridge Analytica? And Facebook, in the meantime, has continually made changes to its privacy settings, including expanding facial recognition and web tracking without user consent. And in the meantime, the FTC, now that it has Facebook under consent decree, actually has civil penalty authority, $40,000 per violation, which, as many have noted now, could add up into the billions or trillions of dollars, depending on how you count the issue just with this one Cambridge Analytica breach. So the FTC should have significant regulatory leverage over Facebook, and yet we haven't seen real enforcement. And in the meantime, we don't have a comprehensive privacy law here in the United States. I mentioned legislative failure, and Facebook's internal checks didn't address this problem either. Neither did their assessments or audits, where they basically got a thumbs up from an outside assessment company to say their privacy program was going swimmingly. So that's a basic background of where we are and how we got here. Next, I'm going to hand it off to David to talk about some of the legal issues and also some discrete civil rights related issues that have come up in this context as well.
Hi, thank you for having me. You know, I'm going to talk a little bit about the civil rights implications here, but I think it's also important to note that in regards to Cambridge Analytica and Facebook, Cambridge Analytica is the high-profile example we know of, but prior to the 2014-2015 change that Facebook made in the access that app developers had to its platform, there were tens of thousands of apps that had similar levels of access. Facebook doesn't know where that data went. Facebook doesn't know what apps were accessing. It doesn't know whether those apps were using that data for abusive or malicious purposes, whether that data was sold to hostile state actors or cyber criminals or other third parties that might want to use it for manipulative purposes. And so, you know, Cambridge Analytica is really the tip of the iceberg here. And so, you know, it's important to keep that in context as we talk about like how egregious this one violation was. It's just the violation we know about. In terms of privacy and civil rights, privacy rights are civil rights. We often talk about sort of this dichotomy or difference between like civil liberties and civil rights, but in the case of privacy, they're really the same thing. When privacy is violated, marginalized low-income and minority groups are more likely to suffer harms and less likely to have the cushion to weather the resulting financial impacts. So, whether it's identity theft or voter suppression, there's disparate impacts from abusive privacy practices, both on Facebook and on other similar platforms. I'm going to talk about a few discrete areas where we've seen significant problems, not just on Facebook, but on other internet platforms as well, but especially on Facebook in certain cases. So first, and most closely related with Cambridge Analytica and the 2016 election, was racial propaganda on the platform. This has been a major focus of the Mueller investigation into Russian interference in the 2016 election. If you are a hostile foreign power trying to meddle in American politics, you're going to target our major social cleavages. And in the United States, that often means racial divisions and religious divisions. So in the 2016 election, we saw a huge upswing in advertisements and promoted content and other pages on Facebook that played on racial divisions. And in one direction, we saw race baiting towards certain voters to raise the specter of, those terrible so-and-sos are going to take over if you don't vote this way. There was a lot of discrimination and racism targeted at immigrants. There was a lot of Islamophobia. There was a lot of racism against African Americans and Jews. It was the classic race baiting playbook updated for the 21st century. In the other direction, we also saw advertisements and content designed to discourage or suppress minority groups from voting. So some of the advertisements that were actually mentioned in the special counsel's indictment of certain Russian operatives talked about ads that were targeted at African American voters and said, you should not support Hillary Clinton because XYZ. Oftentimes these ads had false materials involved with them. There's a lot of fake news tied up with these ads. And they were made by phony accounts for propaganda purposes. Some of the fake Russian pages specifically were designed to mimic pages by the Black Lives Matter movement. So there was one high-profile page in particular called Blacktivist that became very popular. It had, I believe, hundreds of thousands of people following it. And it was a fake organ of the Russian government. And it was designed to stoke racial tensions and be divisive for the purposes of meddling in our politics. So that's one way in which these sort of platform problems directly implicate civil rights. The other thing we've been seeing recently over the past couple of years is a huge spike in online white supremacist and neo-Nazi activity. Historically, if you had a smattering of violent extremists spread across the country, it was sometimes difficult for them to find each other and network and share resources and incite violence. The rise of social media has made, just like social media connects communities all over the world, it also connects the white supremacist and neo-Nazi communities. Just in the past couple days, there was some new research that came out showing that Facebook's suggested friends feature had made it easier for ISIS sympathizers to find others who might want to join ISIS or support ISIS, and it became a recruiting tool. We are hoping that Facebook conducts similar research domestically to find out if those suggested friends features have played a similar role in connecting white supremacists and neo-Nazis in the US. The other aspect of this is, as online white supremacy has blossomed, there's been uneven and lacking enforcement on Facebook and on other platforms, especially Twitter, of their own codes of conduct. So the vast majority of major online platforms have some sort of code of conduct that prohibits encouraging violence or inciting hatred and threatening minorities, those sorts of things. These policies, if they are enforced, tend to be enforced very unevenly. And we have also seen evidence that when they are enforced, it tends to be whoever makes the most noise and complains the loudest gets enforcement. And one of the strategies that we've seen by online trolls is to specifically target Black Lives Matter activists and other civil rights activists to flag their content as violating the platform's terms of service and get that content taken down. While, you know, I can go on Facebook or Twitter and find ample examples of Nazi imagery and white supremacist imagery being used to stoke racial and religious tensions. So as we go forward, it's extremely important that these platforms learn how to police their own platforms and walk the walk. Trolling on these platforms has a significant and chilling effect on minority populations and the targeted communities. When you have a platform that tolerates online harassment and cyberbullying and incitement and threats, it hinders the civic participation of the targeted communities and really ends up reducing speech on the platform, and that's a major concern. And then finally, you know, these communities these white supremacist and neo-Nazi communities are inciting real-world violence as well. So as we saw in the recent Toronto attack, that perpetrator was part of this extremist men's rights movement that organized and mobilized on the internet, and there has been a substantial amount of support and incitement of that sort of activity. So we're very concerned about how these platforms are policing themselves to counter this sort of white supremacist and neo-Nazi content. On the consumer side of things, there's a lot of concerns on Facebook and elsewhere, but mostly Facebook because they're such a large player in discriminatory advertising. So there's concerns about bias in the algorithms that deliver ads, and especially there are concerns about allowing advertising in housing, employment, and credit contexts based on discriminatory terms. So there's been some lawsuits against Facebook for this. There's one big lawsuit pending that is alleging that Facebook is allowing prohibited unlawful discrimination in housing ads. And you know, if you go onto Facebook's ad platform and you want to place a housing ad or an employment ad or credit ad, you can pick pretty much any sort of term you want to be included in the targeted group or excluded from people that you don't want to see the ad. Following some major news stories last year from ProPublica about how this feature could be abused to discriminate against racial minorities, Facebook put up some guardrails and put into place. They said they would no longer allow these ads to be targeted based on race, but there's a huge host of terms that they still allow these ads to be targeted on that can be used as very close proxies for race or gender or orientation. You can even target ads based on the location of other Facebook users. You can do actual redlining in housing ads on Facebook sometimes. And so, you know, this is not an area in which necessarily there needs to be new law. We already have very good laws on the books under the Fair Housing Act and elsewhere prohibiting this sort of discrimination. Finally, we also need to be cognizant of and careful about law enforcement surveillance on the platform of immigrants and civil rights activists. You know, there's been a lot of talk recently about the State Department and DHS requiring immigrants to give up their social media handles as a condition of getting visas to enter the country. And that is an area that is also of significant concern to us. One promising note that I'll end on so that I'm not a complete downer, Facebook last week did announce that they are going to undertake a civil rights audit. It's being led by the same team that did a recent civil rights audit at Airbnb. We are cautiously optimistic that this audit will be thorough, transparent, and address a huge host of issues relating to civil rights and diversity on the platform. And we hope that the auditors will have a transparent and productive dialogue with all of us as well in both the tech policy and civil rights community. So thank you.
Great. Thanks, David, for that really good overview. And as you guys can see, there's really quite a broad range of issues that tie into this Facebook debacle with Cambridge Analytica and other related issues in this space. So I'm going to throw it over to Amie to talk a bit more about what's been happening on the policy front, specifically here in the US, including proposed legislation and some regulatory reactions.
Thanks, Alan, and thanks everybody for showing up on our digital day. I don't know what you want to call this platform, but thanks for coming out and listening to us all. I've been asked to talk about 3 subjects, which I'll do briefly and try to give you an introduction. The initial reactions from lawmakers, the proposals that we've seen come out of Congress, prospects for those proposals, and then I'm actually going to end with a brief overview of the international context that I think is really important here, and add that as a really short 4th topic to cover. So first, with reaction of lawmakers, most members of Congress did what members of Congress do best. They called for a law, and that is one of the most immediate things that we heard, is that somehow this behavior, either it was unsure whose behavior they were targeting, and depending on what day of the week it would change whether it was Facebook's or Cambridge Analytica's or Alexander Kogan's and his companies. But there was kind of broad belief coming out of Congress that what had happened shouldn't have happened, that somebody acted improperly, and that some law needed to be passed to fix it. The most significant movement we've seen in that direction are the 2 hearings where Mark Zuckerberg came to the Hill. He testified in the Senate and in the House of Representatives. And if anybody else actually sat through the entirety of those 2 hearings, I have to clap for you a little bit. They were very long. There were lots of questions. You had to hear Mark Zuckerberg talk about his dorm room quite a bit and what he did in it, namely developing Facebook, according to him, which was really interesting. The things that he did other than that, he apologized a lot, to the extent that one of the members of Congress, it's losing my mind about which one it was specifically, actually went back in time and identified all of the different times that Mark Zuckerberg has had to apologize for behavior that Facebook has engaged in the past, and the fact that he always uses almost the exact same language every single time. But this time was no exception. He did come out and apologize for Facebook's role and his own role in this incident. He explained Facebook's business model, which I won't go into in detail because Alan, I think, started with a really good overview of what happened here. But he talked about how the back end of Facebook works, their relationship with advertisers and developers and people who use their API, and tried to explain to members of Congress, many of whom it was clearly obvious don't understand the technology very well, and had probably received briefings from their staff on the technology that morning or that week, and were trying to ask questions, but he was very easily able to outpace them on discussions of technology. He did talk a lot about looking to uses of emerging technologies. You heard the term artificial intelligence raised quite a bit, and Facebook's desire to use more AI in the detection of and policing of certain unsavory content, and I'll get to that a little bit more in the end. And then he frequently, the last thing that he kind of did often was say that he needed more time. So a lot of his answers to his questions were asking the members of Congress who were posing the question to him to give him a little bit more time, and that he would respond after the hearing in more detail after he had time to talk to his staff. So that is a really quick overview of many, many, many hours of hearings on the Hill, which he himself actually made fun of last week in the big Facebook summit, the F8 summit, where he was talking about having to share images and videos of himself testifying with his Facebook friends. What has come out of those? So we've seen several bills introduced, both last year and then reintroduced in the wake of this incident, as well as newly introduced coming out of this incident itself. I'm going to go over them very, very briefly and give you the bill numbers in case you're interested. We have an explainer available on our website if you'd like to see these in more detail. But I don't want to get too into the weeds right now. The first is the Consumer Privacy Protection Act. It's S2124 and HR 4081. I think that's an 8 that I have written down. It might be a 6. I think it's 4081. This is Senator Leahy's bill. He is the primary champion of this bill. It creates a lot of different, has a lot of different pieces to it. One of the main pieces is that it would take a lot of the provisions that we've seen in the Federal Trade Commission's consent decrees with companies and put them into law for all companies to have to comply with them. So it takes that approach of looking at what the FTC is requiring of companies to run afoul of its unfair and deceptive trade practice authority and putting those into law. Second one is the Browser Act. Everybody knows members of Congress really, really love acronyms. These bills are no exception. This is the Balancing the Rights of Web Surfers Equally and Responsibly Act, HR 2520. This was introduced by Representative Marsha Blackburn, who is well known in tech policy circles for both having opposed net neutrality regulations in the FCC, as well as the broadband privacy rules that were implemented by the FCC and then later vacated by Congress. This act takes a opt-in approach by allowing or an opt-out approach by requiring that users have an opportunity to opt out of certain types of data sharing and collection. The next one is the Consent Act, again, acronym, Customer Online Notification for Stopping Edge Provider Network Transgressions. I don't know who comes up with these. I really want that job one day, just to come up with acronyms. It's S2639. This was introduced by Senators Markey and Blumenthal. Requires opt-in consent for collection, use, and transmission of certain sensitive data, among other things. The My Data Act of 2017, Managing Your Data Against Telecom Abuses Act, S964, HR 2356. Also Senator Blumenthal, this time with Representative McNerney in the House. It basically states that it's unlawful for a broadband provider or an edge provider to use an unfair or deceptive trade practice relating to privacy or data security. So again, going back to the FTC's authority and expanding it just a little bit and writing some more things into law. A quick clarification, a broadband provider would basically cover the telecommunications companies, whereas edge providers, if you're not in the United States, this is frequently known as an over-the-top service provider or an OTT provider. And these are companies like Facebook, Google, Twitter that operate over the top of the networks. So any social media company that you can think of, Netflix, media companies, those are all OTT providers. And this one would cover both of them. The Secure and Protect Americans Data Act, no acronym here. This is HR 3896, introduced, and I'm going to apologize in advance, by Representative Schakowsky, I believe is how you pronounce the name. This is another one that provides more authority for the Federal Trade Commission to promulgate regulations, primarily on reasonable information security practices, including the collection, use, sale, dissemination, and maintenance of personal information. And then finally, the Social Media Privacy Protection and Consumer Rights Act of 2018. Again, no acronym. This is S2728. It was one of the more recent bills that we saw introduced from Senators Klobuchar and Kennedy. This is quite a lengthy, novel approach for a bill. What it is trying to do is provide for clear language for privacy policies from companies, and it wants companies to have to write those in clear and concise language that people can understand. It also requires greater transparency and the ability to opt out or opt in some cases, to data sharing. Across the board, and I won't identify every single issue that we see with the bills, some of them have strengths and some of them have serious weaknesses. A lot of the weaknesses that we see in different bills, I talked about this once, only codifying the provisions of the consent decrees. Facebook, as Alan started, was already under a consent decree when this activity happened, and we can see in both the fact that it happened as well as the lack of enforcement from the FTC against Facebook, both in the immediate aftermath in 2015 as well as through today, that consent decree might not be necessarily have all of the teeth that it needs for that to be a comprehensive approach to regulating this behavior. They are not evenly applied. While some provide or apply to edge providers or broadband providers or internet service providers, very few of them apply to both. And even more of a gap is that they don't apply to all of the other companies that collect user data. Privacy and data protection is not something that is only an issue online or for these specific types of companies. It's an issue for anybody that collects information. And so these take a very narrow approach by only applying to certain types of companies. Many of them don't provide any real standards or rights for user data, only asking the FTC to look into this issue and promulgate regulations, which could lead to very meaningful protections. It could also lead to weak protections. The APA process for anybody who's engaged in it is not always predictable to determine what types of rules are going to come out. Many of them, most notably the Blackburn bill, takes an opt-out approach as opposed to an opt-in approach to data, which anybody who works in privacy has generally agreed that an opt-in approach is necessary in order to adequately protect information, that those defaults matter. And finally, many of them, if not all of them, have very narrow definitions of what information is implicated to be protected. And so it wouldn't necessarily be all personal data, only personal data that falls into very specific categories. We've seen this also be a problem in many data breach notification bills, that it doesn't anticipate the wide range of data that is necessarily important to users, as opposed to the financial data that people see, especially people in power, see as more likely to cause specific measurable harm. Real quick on prospects for success. This is not the first time we've seen data protection bills in Congress. It's happened many times before, most notably and recently, the push in the Obama administration to codify the Consumer Privacy Bill of Rights. Unfortunately, that provision was both too weak for privacy advocates and too robust for companies, and it wasn't able to get the support it needed to move forward. Here, I think we're seeing a lot more sides of the issue coalesce around needing an approach. Unfortunately, we're also seeing many fewer steps taken by Congress to be able to move any bill forward. There's generally a stalemate in Congress on all sorts of issues. So the prospect of this being the issue that can break through that stalemate is not as certain as I think many people would like it to be. But people's constituents are raising the alarm. We hear this issue being brought up frequently with the people that we talk to, and we're taking those concerns to the Hill. I know many other groups are communicating what their members and the people they work with are saying up to members of Congress. So there is definitely clamor. A word, and this relates to some of the things that David Brody brought up. This is a really rife issue right now. It is not only an issue of data protection, but other related but tangential matters are getting looped into this conversation, roughly around the idea of regulate Facebook or regulate the internet. So we're seeing issues of antitrust being brought up and consumer or internet monopolies. A lot of speech and content moderation issues are being brought up, from fake news, harassment, countering violent extremism. All of these issues are coming up, and people are pushing their own pet issue through. So data protection is just one piece of this approach to, like, let's regulate the internet more robustly. And from a human rights perspective, we would definitely like to see data protection rules, but we are trying to be clear that we don't want any laws in place that will lead to more censorship, both legally or pressure companies to engage in greater amounts of censorship of legitimate content. And then I promised I would end with a brief overview of international context. The GDPR is going into force soon, like it or not, the European General Data Protection Regulation. So we're talking and hearing more about privacy now, because I bet every one of you has received at least 20 messages in your inbox saying our privacy policy has been updated because of the GDPR and the need to do that. Facebook is itself taking a lot of, making a lot of changes because of the GDPR that it is conveniently tying to this Cambridge Analytica incident, even though it's not necessarily related. India is also looking at data protection. Many countries in South America, Tunisia is likely to pass a data protection proposal. And so the US, if we're not talking about this, we're actually continuing to lag behind internationally as the push continues to be for regulation on this issue. And I will end there. Thank you, Alan. Thanks, everybody.
Great. Thanks, Amie, for that excellent overview. Now I'm going to kick it over to Jody, who's going to talk about how this issue has sort of flowered in the US, but also internationally, how it affects businesses, and a little bit more about the international side of things.
Thanks so much. It's a pleasure to be here. Thanks to all of you who joined for the call today. I'd like to talk first about what impact this is going to have on consumers, and how it might impact their behavior, because then I'd like to move on to then what about the impact of businesses. But with consumers, I think it's very interesting that finally it was this event. You know, we always wait to see what's the event. What was the Me Too event? That finally, after all the different years and complaints and the sexual discrimination and harassment, this one event triggered it, and it was a big, egregious event. And this, to me, was the big, egregious event that triggered privacy for consumers, where they began to understand finally, for what I believe is really the first time, the real power of big data. Through these years when I would be concerned about surveillance, about government involvement with our data, what they're doing with it, what do they have, people would just shrug and say, I don't care. I have nothing to hide. And I think finally this incident brought everyone to an awareness point a bit further down the line. And they could see that, oh, well, they can correlate and connect data and put it together, run it through algorithms, come up with profiles and information about me and my family, my kids, my friends, and that it was a little spooky, that people finally became more aware of the privacy risks associated with social media platforms in particular. I hope that this incident will remain alive and spur consumers to leverage the hammer that they have, that they really haven't been able to wield very effectively so far, and that is market forces. They are a market force. So if you think about Jessica Alba and her Honest company, and she's a billionaire because she came out and said, we're honest, we're truthful about what we sell and our products we have. This is a real chance for consumers to demand that companies respect their privacy and go to those companies and sites that do that. So consumers have the chance now to really wield the hammer and say, I matter and my data matters, and I want to deal with responsible organizations and companies. So now to flip to the companies, businesses also need to take advantage of this opportunity. And they need to, a couple of them already came out and said, we are not going to advertise on Facebook any longer. And made a statement that the reason they did that was they wanted to support privacy rights and individuals and their consumers. And to me, that was a really positive step. And they have a chance now to build a brand on honesty and respect for privacy, which I think could be extremely valuable right now in the marketplace. The opportunity's there. They should be seizing on it. There's another reason they should be seizing on it. They need to distance themselves from Facebook. They need to make Facebook be the cheese that stands alone. I don't know. Maybe the audience is too young. When I grew up, there was old McDonald's farm, and it was hi-ho the dairy-o, the cheese stands alone. And at the end, it would only be the cheese. Because Facebook, I think, really has behaved badly. As Amie said, their whole manner throughout their existence has been to beg for forgiveness instead of seek permission. And so they will apologize and trot out the same language every time Mark Zuckerberg is a bad little boy who now knows better and is going to behave better in the future. And that just needs to stop and go nowhere. And people need to recognize that it's bad corporate behavior. The risk that all companies could go down a slippery slope into some serious privacy regulation with this incident, I think, is pretty high. I was amazed. I was trying to take notes to Amie's list that she was going through. We don't know where all this will go. Congress has never been able to enact a breach notification law. But certainly the state attorneys generals are active. 37 of them have sent a letter to Facebook. And so they're all riled up. The EU's all riled up. They formed a task force of all their data protection officers. The UK and Canada also has investigations going. As Alan mentioned, the FTC has now revved their forces back up again. And so I think there's a real risk that all companies could get caught in the slippery slope of, oh, we have to solve this problem so it doesn't happen again. And to do that, they're going to make sure it applies to everybody. So companies that can push forward a brand of respect for privacy, I think, will fare well in pushing back against these regulations and laws. And why is that important? Well, it's important because, one, no one, as Amie pointed out, Congress doesn't get technology very well. So that was very obvious in the questions they were asking of Mark Zuckerberg. So it's very important that we make it very clear that we want our companies to be respectful and have good governance practices, but that we don't necessarily want to go to the extreme of the GDPR. Why? Because of the expense. No one talks about how expensive this will be. And yes, privacy is important. I value it. Many of you know how much I value it by things I write. But when you start looking at applications, every company today is run by information technology. And those applications simply are not coded to allow opt-in, to allow you to have instant access to all of your data, to allow changes to that data, to many of the requirements of the GDPR. And so that this is requiring systems analysis, coding changes to applications. We could be talking hundreds of millions of dollars for big companies. And so it's much better to take the approach we've taken all along, which is to steer companies toward good privacy practices and principles and make them have their codes of conduct and be honorable in how they handle data. I think that's the far better approach. The EU may be going a little over the top with GDPR. We'll see if Facebook turns out to be their poster child. That would be an easy one for them. But I think that the businesses right now really need to be on guard. A word about when we're talking about businesses with their governance practices. Facebook has very bad governance practices. You know, they don't have a culture of compliance. They don't have a culture of respect for policies, enforcement of policies, of good audit practices. They didn't do anything. Their mode of operation was always, it's better if we don't know. We're not going to ask what these app developers are doing with this data. It's better we don't know. And Mark Zuckerberg clearly admitted when he started this platform and opening it up to app developers, he wanted them to be able to get all this data because it would attract them to the app. Facebook all along has been about money, 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 and basically growing as big as they could grow. So they're arrogant. They're 1.5 billion users or something like that. But when you look at how they've treated Alex Stamos, who's their chief information security officer, or was, and he's put together a group of engineers and quickly came into realizing what was going on with Russia's use of the Facebook platform and users, and tried to bring this to the attention of senior management. And the more he kept saying, we need to be transparent about what's happening here, they shoved him aside, took his team of 120 people, assigned those to a couple different business units. He's sitting there with 3 people now, and they're asking him to please not leave. So I'm sure they plied him with some good options or a big bonus or something to wait till August to leave so it would look better for Sheryl Sandberg and Mark Zuckerberg. But this is not a culture of good governance. This is a culture of bad corporate governance that may really end up costing them a lot of money. Right after this hit, it cost a $75 billion drop in market cap. But then we also have a class action lawsuit that's been filed against them. It's a securities class action lawsuit that they were making false statements on their public filings about the stability, their security program, the maturity of the program. And because they knew that at Cambridge Analytica had taken this data, that this had happened, they didn't disclose it. Securities lawsuits are a new angle of director and officer lawsuits following notable breaches. There were securities class action lawsuits with PayPal and also with Equifax. And many of us believe that these have some merit and that they may start getting some wins in courts. And at a very minimum, they may get their insurance policy saying, we're not going to cover this stuff. So I think that with the companies, it has to be taken a look at governance practices, enforcement of policies and procedures, having a good culture, and taking this as an opportunity to set yourself out front as a good brand and a good corporate citizen, someone people would want to do business with. Let me stop there, Alan, and give this back to you so that we can continue forward with your questions.
Great. Thanks, Jody. That was really helpful as well. And I think I just wanted to note there's a couple questions in the queue already, but for those on that are joining us on the webinar, you have the ability to submit questions. So I'll be sort of repeating and soliciting those questions to get your answers. And then I have some questions myself, and I hope we can have a little bit of back and forth. At the outset, just following up on a couple points that were raised by David and Amie and Jody during their conversations. I agree with Jody that, thinking about this in terms of its this Facebook Cambridge Analytica story, in terms of its significance as kind of a wake-up moment for this issue. I do think it's kind of shifted the Overton window a bit, and certainly brought focus, as Amie has noted, of Congress, but also of constituencies to this issue, and not insignificant also that it's an election year when that's happening. So I think that this really is, for the broader consumer rights and civil liberties community, this really is an important moment that we need to find the best way just to take advantage of. I think in terms of thinking of the how we got here problem and the what happens next problem, a lot of the conversation, whether it's talking about, Congress's questions or the FTC's capabilities, or comparing the GDPR to what we've had in the United States, there's always questions around different models of, be it corporate governance, regulation, legislation. So I think it's just interesting to keep in mind, these are obviously complex systems on some levels. Some of the issues that we've talked about are fairly straightforward, like access by these third-party apps, not hard to understand, but addressing these issues in a kind of a comprehensive way requires, some different methods. Some of it, I think ultimately the answer is always a mix, right? A mix of statutes and regulations and active enforcement, both by government officials and non-government officials in the legal system, outside the legal system. But also helpful to keep in mind, as we've noted, that there are a lot of different layers of responsibility and accountability here. We have, international laws and norms that are coming into play through the GDPR. We have obviously things here at the U.S. at the federal level, including FTC's authority, but then also at the state level. If the federal government doesn't act quickly, then California or some other state may step in and impose their own regulations, and then companies really may end up in an even worse situation where they have to decide, okay, do we just comply with the California rules in all of the United States, or do we try to differentiate where data is coming from? As a quick aside, that's essentially where the EU model, the GDPR approach, comes from. The countries in Europe have to agree to common standards, or else any company that wants to operate in Europe has to deal with a bunch of disparate standards. So that's really where that is coming from. So let me start by taking one question from the audience. I'll just take the first one, and then I'll follow up with some additional questions. So this is kind of a question that gets to this point about this wake-up moment or the reaction of users. The listener notes that a Reuters Ipsos poll results has shown that 3/4 of Facebook users are just as active now as they were before the scandal. So is this sort of like an apathy among users, or what does this say? My own thought on this issue is that, I don't think it's users' responsibility to delete Facebook, to unplug from the internet every time they hear about a privacy violation. And I don't know that activity on Facebook is necessarily a very good proxy for how much users care about these issues. I think users really do look to lawmakers and regulators and companies to police these policies. And Facebook has repeatedly said, we're doing the right thing, we're making changes, here's the changes we're making, right? And for the whole problem here is that users aren't in control, and users can't know in minute detail at any given moment what data is being collected about them. So this is not a system, I think, that is solved purely based on kind of users changing their settings, users voting with their feet. I don't think that's enough here. But to others, Amie, I don't know if you have thoughts.
I mean, I'm sure David, Brody might say the exact same thing, but the delete Facebook movement, I think, comes from a really privileged place for a lot of people, especially when you look at the international context. Organizing, activism, demonstrations, people have their jobs largely linked to Facebook internationally. And so it's not as easy for other people to walk away as it might be for some people. And we have to recognize that families also go through Facebook. There's a really excellent piece that was written by Sarah Zhang, who's an attorney and a journalist, about the social implications that she faced when leaving Facebook, and how she was not as able to operate in her personal life without that system, because people assume that you have that system. And so it's really a societal move that would have to occur, a shift that would have to occur, I think, to get people to leave en masse. But otherwise, Alan, I agree with you. I don't think that's necessarily indicative of people's attitude toward Facebook. I also think there are generational concerns. As generations shift, we're going to see people use different platforms. Just like previously we saw MySpace fall to Facebook, there's going to be a new platform that I think will probably pop up at some point in the future. And in the meantime, we have to make sure that anybody who uses this platform, the next platform, or any other platform out there is adequately protected, and has the controls and the transparency, and beyond controls and transparency, the rights behind them to ensure that their data isn't abused. And that is our job, I think, as advocates.
I would also say that there's a competition aspect to this, right? Like, if Facebook is not a monopoly, it's pretty darn close. So, users don't necessarily have a good option for a lot of the reasons that Amie mentioned. To put it in context, my internet service provider at home is terrible. I have terrible service. I think I overpay for it, but I haven't cut off the service because I don't have another option to get internet at my house. Similarly, our social networks are tied up in Facebook, and if that data is not easily exportable and interoperable, if there's not other platforms that we can go to with our data and easily recreate the same experience, there's a lock-in effect. And so, like Alan said, the burden is not on the consumer here. The burden is on Facebook and regulators to police what is essentially a monopoly.
Jody, do you have thoughts?
No, I mean, let's just let it go and have more questions.
Sure. Sorry, I'm just checking. Question for Jody. If companies are having to sort of recode and comply with the GDPR already, shouldn't they be able to use some of that cost? You mentioned the cost the companies have to incur in terms of GDPR compliance. If they've already spending that money, then shouldn't the US users basically benefit from those changes as well?
Well, you have to remember that not every company is subject to the EU GDPR. Right. And it's the small and medium-sized businesses that drive our economy. They're the ones that create the jobs. They're intensive users of technology. And they don't really have, I know from my work in the cybersecurity field, it's hard for them to come up with enough money to just maintain and to do cyber risk assessments and those kinds of things that are an added requirement now. And so looking at installing new apps and doing systems analysis and trying to get changes to commercial off-the-shelf apps to do this, and then deploy those in their environments, there are an awfully lot of companies, certainly in the United States and in other jurisdictions, that are not using applications that are GDPR compliant. So I would not want GDPR to be the driver. I think that we have to look at what do these things cost. When you start adding up the cost of regulation, it can be an enormous burden on business. And we know that technology has been a real driver of our economy. that it's created huge efficiencies in our productivity, and we have to try to maintain that balance and with innovation while we also protect privacy. So I don't think necessarily we say GDPR is the answer, so everyone should just go be GDPR compliant.
You guys have thoughts on that?
Yeah, if I could just go ahead, David. I'll let you go first.
Yeah, please go ahead.
Just not to disagree with Jody a little bit. I mean, I think that companies have benefited for a really long time from the lack of regulation. But that if we don't change things now, we're going to further ingrain a system that allows tools to be built with poor security and poor privacy protections in mind. And as technology is expanding and it's becoming more and more common throughout our lives, particularly with the Internet of Things, I think we really need to be focusing on what our future looks like if we don't make those protections mandatory now. And yes, because there were no regulations before, there might be a cost in now implementing regulations. But from a human rights perspective, I think those costs are really necessary. And from data breach to just glaring insecurities in every single sector that technology touches that could have catastrophic consequences if exploited in the right way. I think that we're beyond the time when we needed to have acted.
But that approach will only cause us to have more privacy violations, because right now, if you have to make companies spend money on changes to their systems analysis and changes to their applications and their business processes to comply with GDPR, they are not going to be spending the money they need to spend to improve their cybersecurity programs. And that's how all these things are happening. Cambridge Analytica didn't happen that way, but all the major breaches, when we had WannaCry, NotPetya, that was because of out of support software and hardware that was being used. We have all kinds of gaps that we see every single day in security programs and companies. If they don't have the money to spend on improving their cybersecurity, they're going to become more vulnerable while we're off trying to meet privacy compliance requirements. And so it's not going to solve the problem. We're just going to end up with weaker security and a lot of burdened businesses.
I think there's a couple different aspects to this. I agree that there are costs associated with privacy and technology, and I think the important question is who should bear those costs? Should consumers who don't have control over the platforms and systems bear those costs, especially consumers who might be from marginalized groups or low-income consumers who really don't have a lot of choices and competitive options? Or should the companies that make the choices about how to structure their systems and reap the profits of their businesses be the ones that have to bear that cost? I recognize that, you know, in any business decision, there are trade-offs. And these companies are making trade-offs right now to increase their profits at the expense of consumers' privacy and data.
Well, wait a minute. You're taking the slippery slope argument. I mean, this was Facebook.
No, you took the slippery slope argument, but I mean, I can take a different one.
Well, it is the responsibility of the companies that build these platforms and make them available to consumers to behave in very good ways and to have good privacy practices. So I will put that back on those companies. But we weren't having this big national privacy debate prior to this Cambridge Analytica incident. So we weren't talking about all businesses in America and privacy practices and the need for privacy laws. We've talked about breach notification laws, yes, stuff like that. But this elevation of suddenly the conversation, and Zuckerberg wanted this. He wants it not to be about Facebook. He wants it to be about everybody in every company. And so by making it that kind of a conversation, we're really not addressing the fact that we have companies like Zuckerberg out there that are behaving in bad ways and hurting consumers. And yes, they should be made responsible. Let's target the bad guys.
I think that, I mean, one thing I'll add to this, and then I can pull up another question, is, or maybe two quick things. One is that I think there's an inherent connection between data collection and cybersecurity risk, in that it's the companies that collect and store the most data that have the biggest target on their back. And obviously companies that store financial information like credit cards and other financial details have an even bigger target on their back. But data minimization is a principle that is alive in the GDPR but didn't originate in the GDPR. And I think in that sense there are relationships between the two. And then the other thing I will note is that, you know, this conversation certainly didn't start with Facebook, Cambridge Analytica. I think the public is awakened to it now, but this goes back decades. I mean, when the EU was formed, they picked up on principles that had been laid out by international organizations based on principles that were sort of drawn up in the US in the 1970s. So this goes all the way back to the Privacy Act and the Privacy Protection Study Commission of the 1970s. That's where we get the fair information practice principles. And also in the late 1990s, when the internet was young, the Digital Marketing Alliance basically lobbied the FTC to take the position that privacy policies and a disclaimer model of internet protection was basically enough for internet users. And the FTC, for the 1 year where Congress was focusing attention on it in 1998, said, yeah, we'll go with that model for adults, but not for children. That's why we have COPPA, right? But the next year, the FTC came back, and then in 2000 basically said, we were wrong. No one reads privacy policies. The disclaimer model doesn't work. We should have regulation. Congress was actually in the process of writing that regulation in 2001, and then 9/11 happened, and all the air got sucked out of the room. So we have been here before with all companies, not just Facebook, and you know, nothing's new under the sun. As I noted, the problems that we're seeing with Facebook and Cambridge Analytica were flagged by Epic and others in 2009, so that was 6 years before this happened. And so Facebook is certainly a bad actor, but I don't think that only bad actors benefit, or sort of only bad actors sort of give rise to the need for regulation. I think that we're in a space where it's complicated and companies don't know exactly what to do on the data security point, on privacy and data collection standpoints, and I think a lot of companies, including small and medium-sized companies, are probably looking for guidance here, and I don't feel like in the US we've given them guidance over the last 15 years. So I think that's an issue as well. There's a couple other questions I wanted to get to. We mentioned already the interplay between EU regulations and US regulations on one question, but just another point that someone made is the side effect of EU regulation going to be to improve privacy practices in the US? And I think that's, I don't know if others have thoughts, but I think it'll be interesting to see, right? I mean, companies like Facebook have said, we're going to change our practices in Europe, and largely we're going to, Zuckerberg basically promised to apply the same rules in the US. And not all companies are going to do that, but there's certainly an effect there. I don't know if any others have thoughts on crossover effects.
I mean, we got the Facebook and other companies have said features like the right of data portability, that they're going to start looking at providing those for all customers, so US and other places in the world. But historically, companies have not provided protections that Europeans had for people elsewhere. And I think with a lot of the rights and protections under the GDPR, it will be a hard fought battle to get companies to apply those rights for people outside of Europe or Europeans, including the fact, I believe a while ago, people in the US were trying to get their data profiles the way Europeans were allowed to have data profiles from companies, and you were not successful. Anybody that I know who requested from the US was not successfully able to receive that.
Yeah.
What really isn't understood here is the data. What data are we talking about? People don't know the amount of data that can be scraped from their computer just by simply going to a website. You can get what you can find out exactly what model of laptop they're using, what their operating system is. You can get their browsing history. You can gather all of this information, their IP address, and just from visiting a site. That's called scraping data. And then there are all of the agreements between these companies that exchange this data, which is why if you're online looking for insulated underwear, then in 15 minutes you're getting an ad for insulated underwear. So there's one thing to talk about a bunch of breaches and companies misusing data and giving data away and being mishandled. But it's another thing to talk about not protecting private information, because we don't have a lot of companies out acting as bad actors. We have companies that have behaved responsibly. Yes, we have the FTC that has done some very fine work over the last 20 years to ensure that our privacy practices and unfair trade practices were not continued. But when we talk about data, we aren't talking about massive data breaches and leaks of private personal information. That does occur. But we're talking about the data that companies allow each other to get from one another. Google, Facebook, Apple probably all have agreements with each other about this stuff, and how that's used. So people don't even understand when we talk about data. It's not necessarily the data that companies are selling. It's the data about users that people are scraping up every time they go to a site.
Yeah, I think that people that there's definitely a lack of technical understanding on multiple levels about what types of data we're talking about here, but the data ecosystem is really central to a lot of this. But David, what were you going to say?
Yeah, sorry, I was just going to say, the fact that there is so much data out there and how it moves between different data brokers and different actors, this is one of the ways in which we end up with problems like discriminatory advertising and algorithmic bias, because there is so much data out there and it's used to create these very comprehensive consumer profiles that can tell a company or an advertiser your race, your religion, your gender, your orientation, where you live, how much money you make, where you go to church, where your kids go to school, which gun range you go to, and which bar you're at 3 a.m. on Saturday night. And that information is then used in potentially discriminatory ways, where certain populations are given ads for products or job openings or houses, and other populations are excluded. And for decades, we have had civil rights laws on the books prohibiting discriminatory advertising in certain sectors, not because discriminatory advertising is bad, or I mean, not necessarily just because it's bad, but also because it's economically efficient to discriminatorily advertise. So it makes more money if you can carve certain people out of your advertisement. And long ago, as a society, we made the decision that that's not okay, and that everyone should have equal opportunity in the marketplace. And so, I think that also has to be part of the discussion when we're talking about these massive data profiles that are getting created and shared across platforms.
One more type, I know, Alan, you want to move on to another question, but another type of data that we should be considering is inferred data. My favorite example that I've always used for this is that 5 years ago, Facebook was saying that they could tell who people were about to date. That is not information you gave Facebook. You didn't say, I am about to start dating so-and-so, but based on your behavior and your patterns, they could infer that. And companies have large amounts of data that they infer about you. A lot of it is this discriminatory data that David is referencing. And to bring it back, Facebook is now starting a dating service. So clearly that type of data has become more and more accurate. And another downfall of a lot of the bills we've seen in Congress is that this inferred data will not be included. So you won't be able to have access to all of your data that companies have about you, only the data you provide specifically to companies, not what the decisions they're making based on that.
Yeah, not what their algorithms produce.
Right.
So, you know, it's not the data that all these companies has. It's the data a few companies have, how they're sharing it with each other, how they're scraping it from, maybe we should not allow all the scraping. That's one thing I'd like. I don't necessarily want everyone scraping my computer, but let's focus on what is going on. We have a few companies here that are platforms that are creating massive amounts of personal information on people that is being collected and shared. And so, you know, I would like a more targeted look at specifically better understanding the data we're talking about and who's doing it.
Yeah, and just another quick point I'll make on that. This is an issue that's been around, especially the web tracking issue that you flagged has been around for a number of years. And one effort that was made, part of the reason why I think we are where we are now talking about broad scale federal legislation is because other methods have failed. There was an effort in the within the group, the WC3, the group that creates internet standards, several years ago to try to create a do not track standard. And it started out as an effort to create literally just a technological standard for web browsers to allow users to indicate that they did not want that information that, Jody, you're talking about to be scraped by websites, and specifically to be collected by third parties from websites using cookies. And basically the Digital Advertising Alliance and others in industry came into that process and shut it down and basically said, no, we don't want there to be a robust way for users to prevent this type of tracking, and just completely gummed up the works and prevented a standardized method of flagging that from being adopted. And it's just part of kind of the one-sided nature of the power dynamics in this area. Let me just do a couple more questions before we wrap up, or maybe one or two more questions before we wrap up. Yeah, we talked about ad tech. One related question that was raised has to do with, this issue of free services, which I guess we didn't really talk about, but I know there are, there are definitely some competing issues. David, I don't know if you have thoughts on this, but one of the things Zuckerberg raised is, the idea that, well, it's not necessarily a good thing if Facebook is just categorically not free because there may be equity issues. I don't know, David or Amie may have thoughts on that, on either the civil rights issues or international issues. But I know it has been raised when people sort of push back against the ad-supported model if ad tech is a lot of the source of the problem. But do you guys have any thoughts on that?
Just briefly, I think it's important that privacy not become a luxury good. We don't necessarily want to get into a world where you have to pay for privacy and you end up in a world of privacy haves and have-nots where only people of means can afford privacy. There was a program by AT&T several years ago where they were going to offer cheaper internet service if you allowed them to mine your data very invasively. And, on the surface, you can see how someone might say, like, oh, yeah, I would love to have a cheaper bill in exchange for this data. And other people might say, you know what, I'm willing to pay more to protect my privacy. I don't think there's a bright line rule here, but I think that we have to just be very careful of the equities involved to ensure that we don't end up going down an unequal road.
Amie, did you have thoughts on that?
Coming from an advertising academic background, I always have found it interesting that at least up until 2 years ago, contextual advertising online was still outperforming behavioral advertising. So we're collecting all of this data, and we've yet to find a way to capitalize on it that outperforms the fact that people who visit ski resort websites probably want to buy or rent skis. I find that a fascinating piece of information about advertising online. The thing we have also published along with our analysis of our bills, a wish list of what we would like to see in what we would call a comprehensive data protection approach in the United States. And one of the things we divided into rights for users, obligations for data processors, and activities that we think the government should engage in. And one of the things in that third category that we're looking for is government investment in alternative business models for the internet. Grants given to companies who will actually invest in and research and development of companies online that aren't based on data. And we're starting to see some of these pop up in different places. There are definitely things like the Brave web browser that are consciously trying to kind of take that business model and brush it aside and look ahead. But we could see that greatly speed up if we start investing in non-data driven business models. And I think that both privacy and security would benefit from such a shift, and we would encourage that.
I hope we also invest in technologies that counter AI.
Yeah, AI was certainly an issue that I had on my sort of hit list, and we didn't quite get to, but I wanted to give everyone a chance to kind of give some final thoughts. Amie, I think also hit another issue I wanted to get to, which was what's kind of missing from the current proposals. But yeah, in terms of the takeaways, where do we go from here? Maybe start with Jody. Do you have any last thoughts or takeaways?
Just real quickly, I mean, we have to remember that if a site is engaging in illegal conduct, then we do have the ability to do things about that. You look at Craigslist and Silk Road, we did things about some of the activities that were taking place on those sites. So there is that ability that we probably ought to look at a little bit closer, especially in the context of what Russia was doing or some of our campaigns. And then I think also what we talked about before, and Amie was making some good points with the advertising. The advertisers are the ones that got this first. Way back in the late 90s, when I was a senior fellow at Progress and Freedom Foundation, we were having events about the internet and the new digital age. The advertisers were there, and they were there first, and people were bleary-eyed looking at them like, huh, what are you talking about? They got it. So they've got the data, and there are some of the big algorithm developers, and so we need to learn more about this whole space so that we can help drive this conversation. I think would be a good point to stop.
Okay, David.
Yeah, I think we are starting to see how there is a role to play at all levels. The platforms have responsibilities and need to be held accountable to them. I think state legislators and regulators have strong roles to play to protect their own citizens. And I think Congress and federal regulators have strong roles to play to protect our nation and our democracy, as well as the civil rights and liberties of everyone. I think we're starting to see more of the tangible impacts of privacy violations, whereas for years and years, there were plenty of us in the tech policy world saying, this is really dangerous. You don't necessarily want to let all this information get out of the barn. And there's always been some effects from that, and I think it's now becoming more visceral, more clear, both in terms of electoral manipulation and even the risks we're going to face in the upcoming election due to poor cybersecurity and privacy controls, and also in terms of discriminatory advertising and other sorts of problems on the platform. All of these things trace back to consumer privacy one way or another. You wouldn't be able to do nearly as much effective electoral manipulation if you didn't have very detailed profiling data on who to target and how. And so, I think it's just become a lot more visceral and tangible in many ways. And I think there a lot of things that can be done at different levels.
Great. Any final thoughts, Amie?
I love that your question was, where do we go from here? Which was the name of our blog post, and also the name of a song in the Buffy musical that we were alluding to in that blog post, because everybody at Access Now is a big nerd. I think that is the question to ask. We support robust legislation clearly in this issue. We think it's at this point necessary. The internet has made this world really opaque for people to act, and we need to protect those people. At the same time, I just want to warn against approaches that border on censorship. Even when the speech that we're looking at is atrocious, those tend to get turned around on the people who we would most like to protect, and we have to look at those users at risk. That's our target group, as well as we have to look internationally. These are not only US companies, they have huge implications for people around the world, and privacy and security can actually be non-hyperbolically life or death issues. And so we have a real serious obligation here to get this right and to get it right in a positive way. Thank you.
Great, thanks. And I'll just add, my own 2 cents on this. I think that we need not only new tools, but we need to use the tools also that we have. Most importantly, I think these new FTC commissioners that just got sworn in have a lot of work to do in terms of catching up and addressing these, not only the Facebook issue, but the platform monopoly issue that we touched on. There's going to be a lot more issues related to AI that we've discussed, and it's a space in need of significant and immediate action at basically every level, from the companies on up through state, local, federal, international governments. So I hope that people will stay engaged and continue thinking about these issues. But thanks mostly to the panelists for joining me and to the ABA for hosting us. And we went over by only like a minute and a half, so we did pretty well, I think.
Thank you, Alan.
Thank you.
Great.
Thank you, and thanks everybody.
Thanks.